Welcome to the Great Divorce Podcast, hosted by divorce financial analyst and retirement planning counselor Andrew Hatherley. Join Andrew and guest experts as they help late-life divorcees build the financial and mental foundation for a meaningful future. There is life after divorce. Now, on to the show.
Hello, everyone. Welcome to the Great Divorce Podcast. I'm really looking forward to today's conversation as my guest and I will be dealing with a subject we haven't covered before on the podcast, and that's the important subject of estate planning and gray divorce. My guest today is Amanda Wedl, an estate planning attorney and founder of the Wedl Law Firm here in Las Vegas, Nevada. Amanda received her Juris Doctorate from Marquette University Law School, where she graduated cum laude. And unique to the estate planning world, Amanda is a certified financial planner, and prior to founding her own law firm, worked in private banking at Wells Fargo. Amanda, welcome to the Great Divorce Podcast.
Thanks for having me.
Very welcome. Amanda, why don't we begin with a basic discussion of what estate planning is, because I think many of our listeners may only have a vague idea.
Sure. So estate planning is the process of somebody organizing their affairs, usually to solve two major issues. One, the event of our incapacity, and the other, the event of our death. So estate planning covers important questions like, who are our trusted individuals that will step in for us to help us with our healthcare decisions if we are no longer to make those decisions for ourselves? Who steps in to make financial decisions if we're no longer able to make those decisions for ourselves? Besides appointing trusted individuals in these documents, the documents also address how we want our assets distributed upon our deaths. So the major governing document is either a will or a trust. I practice under the laws of the state of Nevada, and Nevada is a very trust-heavy jurisdiction, meaning our major governing document is a trust, not a will. Eastern states may be a little bit more will-heavy. Their major distributions upon death occur in a will and not a trust. So with estate planning, you are going to have a variety of documents: your healthcare powers of attorney, healthcare directives, financial powers of attorney, a will or a trust, maybe assignments or deeds for specific asset transfers. I also do digital asset planning, which is very important now with the amount of information stored electronically and the allowing somebody to access these electronic records. So in Nevada, to use this analogy that we'll use throughout this podcast, I think, is for a governing instrument like a trust, we view it like a suitcase where my clients are coming to me and I help create a suitcase for them. And this suitcase is like a receptacle to hold legal title of most of their assets. If a client properly packs that trust suitcase by retitling those assets, in Nevada, that suitcase can avoid probate or that court kind of supervision of a transfer of assets upon somebody's death. And that suitcase can be efficiently transferred to the next decision maker that you have appointed. And then that person can unpack that suitcase for the benefit of the beneficiaries. So in Nevada, you'll hear me talk about a trust or a suitcase, and that's that analogy.
Well, I love the metaphor of the suitcase, but I'm imagining that too many people, unfortunately, haven't purchased the luggage before getting divorced. And so in a minute, I'd like to talk about, what happens to the suitcase during and after divorce. But what about those people who may not have done any estate planning? how would you deal with them during the divorce process?
Yeah, great question. So if you don't have any planning in place, your state law has created statutes to do that planning for you. And those statutes generally follow what the average person wants to happen with their planning, meaning the average person wants their spouse to be their healthcare decision maker. The average person wants their spouse to be their financial decision maker. The average person wants their spouse to inherit their assets, or if not their spouse, then their kids. And there's a certain preferential order, and those laws are set forth in a state's intestacy statute. So to die intestate means to die without a will or a trust or other planning. And these laws appoint the decision makers for you. So if you do not have planning during a divorce and a death occurs, if the divorce is not final, the default of your state statutes will probably say that your spouse, who is not your ex-spouse yet, inherits all or a good portion of your assets, and that your ex-spouse is your not ex-spouse yet, your soon to be ex-spouse is your decision maker for those assets.
Well, that could be a tricky situation. Um, what about if a couple have this trust suitcase during divorce? Can they prepare for divorce, or are they bound by the laws of divorce in their state?
Yeah, I think in preparing for this podcast, I think this is the most complicated area of this discussion, meaning the area of you're in the process of a divorce. What are your options in the estate planning arena? After the divorce is final, it's more clear. It's a little bit more cut and dry, and you have a much more clear legal authority of what you are allowed to do next. When you are in the process of a divorce, it's a lot more confusing. State laws are all over the place. And if you already have planning in place, your governing instrument might say another thing. So, for example, for a trust suitcase in a state like Nevada, where we have community property, some trusts might say that no matter what, one spouse is allowed to change the provisions of her separate property side, and that same spouse can control her share of the community property side of that trust. So the trust instrument might already give the spouse the ability to change her share of the trust without the consent of the other spouse. However, some other trusts still in Nevada, still under the same law, because it was an agreement between the husband and wife at the time. Some other trusts might say that no change can be made to the trust without the consent of both parties, without the consent of both the husband and the wife, that the amendment must be done by both. So in some ways, you might be limited or not limited by the governing instrument. But this is a very tricky area. This is a very tricky law, because you might be prohibited from disinheriting your spouse during the process of divorce before the divorce is finalized.
Those would be the court orders, correct? That would
Right, those
prevent
would
you
be
from making those changes.
correct. So one idea that you can always think about is maybe to pursue some sort of property settlement agreement with your spouse during the divorce process before the divorce is actually finalized. And these property settlement agreements can address well, what happens if one of us passes away during this process? Do we get to still inherit from our spouse? Or do we waive our rights in our spouse's estate? Or do we waive our rights to be the decision maker of the spouse? And in divorces nowadays, as I'm sure you know, Andrew, all divorces are different. Some of us might want to be done with our spouses and waive all interest. In other cases, it might not be smart for one of us to waive our interest in another spouse's estate. So each situation is very different. And I would say this is the part in a divorce where you really want to act in concert with your divorce attorney and an estate planning attorney to get very clear on what you're allowed to do.
That's so important. You mentioned something that's particularly relevant to the world of gray divorce, where you have people getting divorced in their 60s, 70s, and even 80s. Is you have, it's a matter of life and death, the potential likelihood of somebody dying during the process. And you mentioned addressing that. And of course, because older people tend to have more health concerns as well. And we know that divorce is a very stressful situation, which can contribute to declines in people's health. So I like what you said about having an estate planning attorney and a family law attorney in communication to address potential issues as to what happens to assets that may be delineated in a trust, but if somebody was to pass away during the process, they may want alternate arrangements.
Mhm. Right. And I understand that this is not what some of the audience wants to hear, right? They're in the midst of something extremely stressful and just unbelievably involved in their life. And the last thing they want to think about is, oh, now I'm incapacitated or deceased. And
Yeah.
I have to think about these other stressful things. But I think that's the role of the advisor, is to help educate, help, lovingly direct, and help take that burden off. And I feel that this time can be also empowering, where you are redefining some of these roles and goals. So maybe just hang in there for those hard discussions.
Well, it's, I've said this many times on this podcast. The one's divorce is likely the largest, most significant financial transaction happening in their lives. And it's happening at a time when quite often we're not thinking clearly because of the emotions involved in the situation and the stress, not only emotionally, but financially, particularly if you're making large payments to family law attorneys on a regular basis. That it really is to the benefit of the person going through divorce to have specialists, not only technical specialists with regards to the legalities of divorce, the world of estate planning, the special situations with the finances of divorce, but also the emotional regulation, whether it be through a therapist or a divorce coach. Um, it's so important to have your emotions regulated as best as possible when going through this, and to have the advisors, as you say, this team approach, which I've mentioned in many other podcasts, is not as expensive as people might think. Because when people are going to an attorney for emotional and financial issues and estate planning issues, they're paying $400, $500 an hour, and they're not getting the best advice. They get the best advice on the legalities of the divorce process, but family law attorneys are not specialists in emotions or financial planning or estate law for that matter. So it really is to the party's benefit to have as level a head as possible when going through this process. And I know you're a big proponent of that yourself. As a matter of fact, you have the more financial planning credentials than certainly most estate planning attorneys.
Yeah, I think, and you're right. No, we don't like to pay a lot. That's not fun to pay all these fees and advisors. But it's very simple to say that the consequences of not making informed decisions are probably even more expensive, because now we're dealing with large assets, like you're going to be talking about 401ks or IRAs passing to the wrong beneficiary. So it's to not have a team of advisors to help empower you through this time, help you make informed decisions, help make sure the I's are dotted and the T's are crossed, can lead to very disastrous financial results.
Certainly. We talked about the trust what during the divorce process. What about after the divorce? So the trust essentially, does it continue? Is it just considered to wither away? What happens to this legal instrument when the divorce is complete?
Great question. So the average answer, or what happens most of the time, is the trust kind of just falls to the wayside and becomes a non-entity, because to be a trust must own property. And in the divorce decree, let's say, ex-wife is going to walk away with a house, a car, a bank account, a brokerage account. The ex-husband was awarded in the divorce decree a second home, a brokerage account, a vehicle, a bank account. Those properties now become the exclusive properties of ex-wife and ex-husband. So now you have to buy new luggage. So the ex-spouses will form a new trust to hold their respective properties that were, awarded to them in the divorce decree.
Do you think? I'm sorry, go ahead.
Because those legal properties were transferred to a new legal trust name, that old trust probably would hold no property anymore. But for belt and suspenders, I would always recommend that the divorce decree, address this specific situation. Maybe state that after the assets get refunded into each respective trust, that the joint trust is dissolved, that both parties should revoke that trust. So there's no question of whether this trust still exists, whether it still has assets. The goal of estate planning is to make it as easy as possible for our loved ones, our decision makers. We don't want there to be a doubt of, does this trust still exist? Does it still have property? Do I need to track this stuff down? Let's just make it very easy for our decision makers and put those to rest.
Better safe than sorry to have it referenced in the
Yes.
decree, as you
Right.
mentioned.
But
Oh,
as you know, Andrew, working with clients, everybody's different. There are for some ex-spouses that still move forward in a partnership, or maybe they still retain a joint asset. And if, in that event that you might have a shared asset with your ex-spouse that you intend to hold on for a while, maybe you have a vacation home and you want to retain that vacation home for your family. And upon your death, you want this vacation home to go to children from the marriage that you have together. These trusts can live on. You don't have to create a trust only with a married person. You can have a trust with an ex-spouse or with a friend. So a trust can also be a very flexible vehicle for this type of planning. So there might be some unique fact patterns that could warrant the continuation of a trust.
well, you raise an excellent point, Amanda. that with respect to the vacation home or even the primary residence for that matter, so many people are loath to sell their properties with having locked in very low mortgage rates, and the prospect of having to purchase a new home and or refinance at much higher rates is leading people to look for creative solutions to potentially maintain ownership together. So I could see that a trust might be that the language of the decree might carve out that the trust would exist for the sole purpose of maintaining joint interest in the home for a certain number of years.
Right. And if you have a unique asset or a planning, a planning goal like that, that is more of a reason to involve your estate planning attorney a little bit earlier in the game with your divorce attorney to brainstorm and to troubleshoot some of these ideas, because there's trust, there's partnerships, there's limited liability companies. So if it's a reasonably amicable divorce where there is some common goals that you and your spouse or ex-spouse can find commonality with and are willing to plan around, there are other legal vehicles that can be created to address those goals.
I'm in 100% agreement. I always counsel people to get advice from the experts as early on in the process before the language of the divorce decree is put together. So many so many mistakes or future flexibility can be dealt with in the language of the decree. So I concur 100%. So let's look, for instance, at some best practices. We got a few minutes left here. Let's look at some best practices a person should do regarding their estate planning after divorce and some potential pitfalls or landmines.
So I think one best practice after the divorce is to revisit your estate plan, to not leave it up to your state law to determine what your divorce actually did, how your divorce actually impacted every single one of your assets, every single one of your legal documents. Empower yourself to make those changes so you're certain that your goals are being addressed and that's nothing is falling through the cracks. So you'll want to update your will or your trust, recreate or rename your healthcare powers of attorney, your financial powers of attorney, and revisit all of your beneficiary designations. Revisit every single life insurance policy you have, your IRAs. Andrew, we know that our clients today, they have several IRAs. They might have a Roth IRA, a SEP IRA, a traditional IRA. They might have a 401k. There are several retirement accounts that a client has. And every single one of those accounts need to be scrutinized as to the beneficiary. Do those beneficiary designations make sense?
That's so important. And I think one potential pitfall is ignoring that or relying upon what are called automatic revocation statutes or revocation upon divorce statutes, which are meant to protect oversights in not updating your beneficiaries after dealing with the emotional trauma of divorce. And I think about 40 states currently have some type of revocation upon divorce statute that impacts beneficiaries listed on IRAs, bank accounts, insurance policies, etc. But it's very important to know that these automatic revocation laws aren't effective for ERISA plans, which are essentially 401ks, or federal life insurance and retirement benefits. And, in those cases, the pre-divorce designations typically remain in place until you change them, no matter what state you live in. And it's really important that you be responsible. And not many people know that. And there's a famous case, the Kennedy versus DuPont Savings and Investment Plan case, where Mr. and Mrs. Kennedy were married from 1971 until 1994, I believe. And Mr. Kennedy was a participant in the DuPont Savings and Investment Plan, which was a 401k plan. And in the property settlement agreement, Mrs. Kennedy waived her interest to that plan. Well, when Mr. Kennedy died in 2001, he had never changed the original beneficiary on the plan documents from Mrs. Kennedy to another person, nor was there a contingent beneficiary listed. So DuPont gave the plan, or awarded the plan to Mrs. Kennedy, despite the fact that she had waived her interests. Well, as you might expect, Mr. Kennedy's children, or his estate, challenged the decision to award the plan to Mrs. Kennedy, and a federal court actually found for the estate. But Mrs. Kennedy had good attorneys and appealed to the Court of Appeals, which reversed the decision. And ultimately, it went to the Supreme Court, which affirmed that reversal. And Mrs. Kennedy was awarded her late husband's DuPont Savings and Investment 401k, despite the fact that she had waived it in the property settlement agreement. So these plan documents are really the Bible of beneficiaries, and would supersede, particularly with ERISA, supersede state law and follow their own guidelines. So it's really important, and I think attorneys might be wise to include language in the agreement that encourages their clients to this fact, and say, hey, you need to go to the original plan document or the original or the plan administrator and make sure you change this designation. Don't rely on the property settlement agreement to do it.
Right. Right, which is why an estate planning attorney could be help the client dot their I's and cross their T's. You know, I do help clients with a change of beneficiary form to make sure that these forms are filled out pursuant to a divorce decree or pursuant to the new estate planning directives. But you're right, for ERISA plans, the courts have held that ERISA needs administrative consistency and efficiency, and ERISA cannot be held to interpret all 50 state laws and the numerous types of property settlement agreements that might come out in each and every divorce. They can't be burdened with those types of decisions. So that is why the ERISA plan documents control, and why it's so important to revisit these beneficiary designations in the estate plan. And to go back to your point about, revocation on divorce statutes, what we're meaning is if you had planning in place, you later were divorced, a lot of these statutes presume that you now don't want to provide for your ex-spouse, and you don't want your ex-spouse as a decision maker in these documents anymore. So some of these laws will say, oh, if Amanda didn't get around to changing her will after she divorced, we're just going to assume that her ex-husband, Brian, predeceased her and can't be the executor and is not going to inherit from her. But even these laws are very different. Some laws in your state might revoke those gifts to a spouse through a will or a trust, but not on payable on death accounts or joint tenancy accounts. So it's not all encompassing, and it's very inconsistent. The other issue that I find with older divorces with kids from the same marriage is maybe you do want your ex-spouse still involved as a decision maker. You have a special needs child, you have a grandchild you're taking care of. And the dynamic is such where you do want your ex-spouse as the trustee of a child share or a grandchild share. Well, we need to make sure our documents reflect that, that a statute didn't come in and revoke that for us. So don't depend on your divorce decree to solve and be your estate plan.
So important, Amanda. So
So
important.
important. Yes.
You're right. And everybody's divorce is different. In
Different.
some cases, spouses will want their exes to be beneficiaries, and they'll continue to be involved in life together one way or another. Amanda, so many questions. If people want to work with you or find out more about their services, first of all, do you work with people outside of the state of Nevada, and how can people get in touch with you?
A great question. So I am licensed to practice law only in the state of Nevada. So my planning is Nevada based only. I do work with some people out of the state. We do revocable trust because they want Nevada law to apply to their plan because of our great asset protection laws. And they have dynastic trust goals for their children and their descendants. And Nevada law might be a better situs than their state law. I work with other out-of-state clients for asset protection planning for their own needs. Maybe they want a Nevada asset protection trust for some of their solvency assets, and they view Nevada as a jurisdiction that they want to do this type of planning. But I'm not licensed to practice law in any other state other than Nevada. And if people want to get a hold of me, they can visit my website at www.wedllawfirm.com.
And Wedl is spelled?
WEDL. Just those four letters.
Terrific. Look, thank you very much, Amanda. This has been great information. I really appreciate your coming on the podcast.
Well, thanks for having me.
So long.
Bye.
Thanks so much for tuning in to this episode of the Gray Divorce Podcast. To learn more or get in contact with your host, you can visit Andrew's website at transcendretirement.net. Also, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show, and we greatly appreciate it. Thanks again for listening, and we'll catch you in the next episode.
Information provided is educational only and should not be construed as legal or tax advice. Each situation is unique and should be discussed with your tax or legal advisor prior to implementation. Andrew Hatherley is not an attorney and does not provide legal advice. Information provided is financial in nature. Advisory services offered through Hatherley Capital Management, LLC. Divorce financial analysis services offered through Wiser Divorce Solutions, an affiliated company.